Thank you, Nita, and online viewers for the opportunity to present to you today about technology used at trial. Today we are talking about the 3 Ps: planning, preparing, and presenting technology at trial. When we refer to technology at trial, we're talking about specialized trial presentation software, PowerPoint, the document camera, sound, microphones, databases, and other technologies and techniques, not always tech, used to present your case at trial. We want to keep things moving in the courtroom and your audience engaged, so using a variety of technology and techniques at trial, like a mix of PowerPoint, boards, flip charts, the document camera, and trial presentation software, is preferable to just endless slides. Trial software allows you to present any page from any exhibit, impeach witnesses with synchronized depo video, or play a compilation of video for a witness that can't come to trial, all at your fingertips. Trial software allows you to call out, annotate, and highlight specific text from exhibits to help you make your point at trial. It would be impractical to create a slide for every page of every exhibit in PowerPoint. The process of putting exhibits into trial presentation software is actually very easy. It's typically drag and drop into the system. But the ease of putting data in has created a false sense of security because there are a wide variety of software and IT skills necessary to use software correctly, and case data volume and complexity continues to grow. Many teams learn the basics and then find out too late they'll have to configure equipment or perform basic IT troubleshooting, which they may not be skilled at doing. There are a large number of other technical and creative skills that casual users may not have. So it's important to use experienced people for large or complex trials and provide entry-level opportunities in trials and hearings where you can tolerate the risk. Today we're going to talk about the areas that are often forgotten in the 3 Ps that end up putting the entire case at risk. And that's not hyperbole. It's why my book is called The Trial Presentation Companion. It's about the companion skills and planning that are often lacking in the planning process, putting case outcome and reputations at risk. But the book also does cover how-to basics for 3 of the leading trial presentation software packages and several companion programs. My name is Shannon Bales. I'm Managing Director at FTI Consulting and have 20 years of experience working at big law firms like Munger, Tolles & Olson, Gibson Dunn, and Latham & Watkins, managing diverse e-discovery teams. I'm on the California Lawyers Association Law Practice Management and Technology Committee. I'm an adjunct professor at UCLA in trial technology, a UN advisor on litigation support technology for war crimes tribunals. Some of my notable trials are the BP oil spill, the UN war crimes tribunals in Rwanda and Cambodia, securities lending for Wells Fargo, talc for Johnson & Johnson. I'm also a Legal Tech Award winner for innovation at trial for my work at the Cambodian Tribunal and for my work at the BP oil spill. Last, I'm author of the Trial Presentation Companion. Problems experienced at trial are typically due to poor planning and project management. Many legal teams think of technology as an afterthought, but fail to practice and plan and take their obligations seriously, leading to poor performance in the courtroom. Legal teams that don't have it together technologically can't support their own team, don't present well, and certainly can't fulfill their technical obligations to the other side. So I wrote the book, and I'm giving this presentation today with lessons from it. 1, to teach legal teams and students how to plan, prepare, and present technology at trial correctly. 2, to help firms understand the risk they were undertaking by not doing it right. To create recognition that poor planning and use of technology at trial can have an impact on the outcome of your case. And last, to aid courtroom efficiency and innovation, because when it's not done right, everything just slows down and it mucks up the process. Now, a Cornell Law Review study, a study recently published in the Cornell Law Review titled, "What Juries Really Think, Practical Guidance for Trial Lawyers" by Judge Amy St. Eve and Gretchen Scavo of Winston & Strawn. It was a study of 500 jurors from 2011 to 2017 in the Chicago Federal Court on what they thought of their lawyers they saw at trial. In other words, what they liked and what they didn't. This slide shows what they liked. And also, this slide shows the top three things that jurors liked the most. And one of them was organizational preparation and efficiency. And the other was delivery style of presentation. Specifically, the study said, jurors prefer when attorneys use technology during trial to organize and present evidence. This aligns with my own observations of juror expectation, where they have come to expect use of trial technology in cases, and they want to basically do their service and get out. So if delaying them by ineffective use of tech or no tech at all, you may earn their anger. The study also stated that jurors also like when attorneys use timelines and make other efforts to marshal the evidence in a meaningful way. I think what they're saying here is they want you to use graphics to help organize and explain exhibits and have a plan when it comes to your presentation strategy. According to the study, many jurors are accustomed to learning through technology, and technologically enhanced presentations present an ideal way for them to learn about your case. This is exactly what technology allows you to do, to select any page from any exhibit, but you'll need to consider your presentation strategy on how you will walk decision makers through your exhibits. We'll talk about that in a bit. Jurors expect you to use technology effectively and efficiently. They don't want their time wasted and don't want a bunch of technical problems. Conversely, it was the same areas that the survey responded suggested that attorneys could do better in. And that's organizational preparation and efficiency, and presentation, delivery, or style. And that all comes down to having a plan and practice. Now, some of the comments from the study. Why couldn't the defense use laptops to present evidence like the prosecutors? I would have liked to see the attorneys operate computers better and learn how to use equipment in advance. And the summary visuals were helpful. So I think the decision makers have become accustomed to technology and want you to use it to help aid them make a decision. So let's begin by talking about the perspectives of judge and attorneys when they use technology at trial. Judges want efficiency. They want the trial to be done quicker, and trial technology is the way to do that. So approaching the setup and use of technology at trial with judges and their staff, you should do whatever you can to make it easy on them and defer to their presentation preferences. Attorneys want to be persuasive and be in line with the Cornell article mentioned earlier. Sometimes these perspectives clash, like when teams don't ask the courtroom for their preferences or permission. They're often bad guests, leading to courtrooms not wanting to use technology at all. By one account, in the federal courthouse in LA, the vast majority of technical problems, way more than 50%, are attributed to teams that never tested their equipment in advance. Far from being government drones or using old technology, the newer federal courthouses are cutting edge with amazing support that equal and surpass anything in private industry. The tech commitment from lawyers and legal teams is often so bad that some courts have created evidence presentation obligations. Now, some of these rules illustrate how bad technology in the courtroom has become. These are from Kentucky and California, but I've seen variations nationwide. In the second bullet point from the bottom, it states, you should know, it says, in addition to familiarizing themselves with the court's electronic evidence presentation system in advance of the hearing trial, the parties must familiarize themselves with their own equipment and how to connect their own equipment with the court system prior to the hearing. What the court is saying here is they expect you or a member of your team to have tested and worked out any issues in advance with the courtroom equipment. Most courtrooms allow some level of access beforehand, or even classes to learn to use their equipment. You or your representatives should attend. Note the last bullet point. The court strongly encourages parties to bring a backup laptop with power supply, flash drive, CD, and contains all documents if technical issues were to arise. So what they're saying here is the court is clearly tired of ineptitude here. The typical fix for a tech issue is to restart your computer. And in court time, that's dog years. So having a backup ready to go is key to helping keep things running. And typically how we do that is we have two computers on a switch. So if one were to break down, you hit a button, and it goes to the other laptop. You can restart the first one and go to the second one. And above, you note in the first bullet point, the court describes that they won't tolerate delays. So the backup and testing go a long way to avoiding problems that show a commitment to the court about doing it right. So there are some things that judges and court staff can do to help aid courtroom efficiency. So first is allowing access. Sometimes it's hard to get into the courtroom, and it's important that we get access so we can do the testing and set up and make sure that everything's working perfectly before the trial starts. You don't want to be testing and fidgeting with things during the trial. It should be a little easier to bring in and use technology. Some courts require an order to bring in equipment or require us to write down all the serial numbers of all the equipment being brought in. This doesn't allow us any flexibility if we need an additional piece of equipment or something breaks. It also is very hard to coordinate that with a rental vendor, which is how most trial equipment is brought, so that we know because we may not know which equipment is being used in advance. It would be very helpful to enforce the standards embodied in the trial management order with branding and naming and using exhibit numbers for communication. When teams don't use exhibit numbers and they use some old number from a document or an exhibit, it can cause problems and delays and confusion amongst decision makers. And last, I highly recommend the use of a third-party equipment rental vendor to avoid finger pointing and problems. Professional legal equipment rental vendors know the legal market. They have backups upon backups of the equipment that they provide, and this is very helpful in case a piece of equipment blows or breaks. The trial environment is a rough environment for the use of technology. You're taking things up and down stairs and steps, and people drop stuff and spill stuff and do all sorts of things to the equipment. So having a replacement readily available is important. Now, next we're going to talk about cause and effect at trial. These are behaviors at trial and their effect on decision makers, along with an answer as to what you need to do. A lot of it comes down to practice and preparation. Calling out exhibits. If you can't call out exhibits and you have difficulty communicating the instructions or being able to do it yourself, you're going to look very unprofessional to the jury. I recently did a trial where the opposing counsel was an amazing attorney, and he was very well spoken and did a good job, but he didn't know how to call out his exhibits in the courtroom, and he clearly had not practiced any of the things that he was calling out or using in the courtroom with his trial technologist. Now, when that happened, what would occur is he would show anger, visible anger on his face, or he would snap back at his trial tech and make all sorts of weird comments about, can't believe this takes so long and that kind of thing. So it really hurt his likability, and I had never seen jurors after they got a positive verdict for our team. I've never seen jurors go out and finger wag to that attorney about how he had treated people in the courtroom, like these jurors did with this attorney. Technical crash. Now, I don't know what the acceptable number of crashes is because some of it is unavoidable. But if you have a backup, as I described earlier with the two computers, nobody will ever notice. So planning goes a long way. When teams don't use an exhibit number, there are teams that will point out the right number and make you look bad in the process. I find that teams that can't replace old production or Bates numbers with the right numbers are lacking in support and technical know-how. And there's no correlation to firm size here, small or big. And last, unable to comply. And this has never really been a David and Goliath situation. What I'm talking about here is teams that may not or may purposefully not do their part at trial, like branding exhibits or the technical format of files for exchange. And what this is burden shifting. And increasingly, teams are pushing back on these kinds of behaviors. So do it right. So do it right so your team's support doesn't collapse. So lawyers have a duty to do it right. You should be asking yourself, how would not knowing the relevant technology or having an expert on hand differ from not knowing the relevant law? I'm sure you would spend all night learning a change in the law, no matter what it took, and tech should be no different. The ABA model rules for professional responsibility address that lawyers need to meet the standards of competent representation of technology-related procedures. Lawyers used to joke about their technical ineptitude in court. I'm not so sure that's a good idea anymore. Now, a quick comment about legal operations. If you aren't familiar with this growing field, you should be. This is quickly becoming a hot corporate job where all aspects of legal services are measured, including trial services. They use the metrics to help guide clients in their search for efficient legal service and keep costs down. So one takeaway from our discussion today should be that firms need to have better workflow, process, and standards when it comes to their technology support, not just trial support, but all their technology support programs. And doing so will make them more attractive to clients. So legal operations adds a business process to everything legal service related. It measures the performance and value of legal teams via using metrics often. And legal teams that are efficient in their service offerings, including trial, will have more opportunity in the future. Now, before we get to the next section on planning, I wanted to clarify a few things. First, technology should not be about jumping through hoops and onerous burdens, but about making the legal process efficient. There is nothing more efficient than working in a trial with opposing teams that are both doing their part. Things move smoothly. It's a almost pleasant process, except for the part that the legal part that you're clashing about. And that's what technology at trial should be, almost invisible. There should be no offensive use of technology, but defense is important. So what I mean by that is standing up to burden shifting and making sure that both teams are complying with rules meant to make the process more efficient. And sometimes they don't. So it's important that efficient enforcing technical standards would go a long way to reaching the court and legal team goals. And courts need to recognize firms doing it right and those doing it wrong. So as we get into planning, try to ensure that your firm is not doing trial by fire, where you are simply learning as you go. Trust me, it's readily apparent to decision makers if you don't have your technology game under control. There are enough tech table discussions, miscommunications, and screw-ups that everyone knows. So plan right. And we see a lot of sacrificial lambs here who come into court unprepared. I'm talking to you associates who usually they're told, just plug your computer in and put in exhibit numbers and everything will work just fine. Well, this doesn't really recognize that courtroom equipment comes in all kinds of flavors. Sometimes there's a lot of configuration to do, and people aren't prepared for this spin on something different that they're supposed to be doing in court. So if you hear, just plug it in and put in a few exhibit numbers without any kind of serious training, run. And do be part of the courtroom site visit if you're going to be asked to do that. The first question to ask for a firm should come long before any specific trial, and that is, what does it mean to have a trial done by your firm? Your firm identity is at stake when you send someone unprepared for trial. It is the highest profile thing that legal teams do. There's often press wandering in the halls, and it's even possible to become like a viral video. So the creation of standards for trial support and e-discovery and everything else for that matter go a long way to establishing your brand as a firm. Standards ensure that there's a minimum level of service delivered to your firm, and so you don't have to reinvent the wheel every time. I've included some basic technical and risk management considerations here. You may even want a committee that is comprised of multiple disciplines like lawyers, IT, paralegals, staff, litigation support, so that you can analyze trials and make sure that there's an appropriate level of service offered at each and every trial. Better yet, a minimum level of service that guarantees how a trial will be handled by your firm. There are many secondary benefits to having standards for trial. Clients are demanding better efficiency, security, and consistent process via legal operations, and this helps deliver. Judges are mandating the use of technology. Jurors want you to use technology. Remember our Cornell Law Review article. And I find it's a great relief internally for there to be standards for both staff and lawyers, knowing that they can depend on some level of help. Last, consultants like me play an important role with experienced people who can aid legal teams. One of the biggest problems firms experience is inadequate project management. Teams simply don't know their data map of case information, whether it's exhibits or video. For example, who has been deposed? Was the depo videoed, and has the video been synced and QC'd? Having this info in a project plan saves time and money. There are many examples of trial teams looking for files and passing on using good information that would help their case because they couldn't find it, and obtain it because it was technically inaccessible. They never thought about it in advance, how they would find or use a file that wasn't in their original population. Good project management entails having a grasp of what you have, where it is, and what its status is. I recall a trial where a depo was requested late Sunday night. It was a mad rush to obtain the video from a paper folder in the home office on the weekend, several states away, and then send it over slowly via FTP. Someone had made the determination that this video was never going to be used at trial, so they never included it in the original planning documents. Lots of time was spent trying to track down the video, sending the video, downloading the video, and it was a very late night. So it could have been a disaster. So having a good idea of your entire data population with a focus on your exhibit population is very helpful. Now, one thing that's helpful is to create a timeline and have milestones in the same way you would manage any other project. Teams want to please the attorneys they work for, and they create situations where there is no room for error, and that is dangerous. It's the famous way of legal thinking where everyone thinks the case will settle, so they do nothing. If it doesn't settle, and you haven't allowed the team to analyze the data needs, your prep will suffer. Trade-offs will be made when there is less time to prepare, and it will increasingly put you in a position of risk and jeopardy. Having a plan from the beginning and using the other pieces of case technology like deposition and document review tools correctly will aid your workflow when workflow when trial rolls around. Most trial techs and paralegals are great at being the hero and doing things last minute. But there are many times where this just does not work out because the team waited too long. As techs, we have a pretty good idea what's happening on the other side when, for example, the other team can't name their files after the exhibit. It means this prep task was cut to do something else. Don't put yourself in an intentionally risky situation. Know your data population and have milestones for the accomplishment of certain tasks. Now, the Trial Management Order, or TMO, are the instructions for the case, which includes technical instructions. There's a lot of abuse when it comes to the TMO when it comes to technology. Teams often play games and don't comply because judges rarely enforce these rules, making it less likely that trial teams will go through the expense and burden of complying with the TMO. However, that is changing as teams are pushing back. Teams have claimed in this commonly used instruction that you see here that they were free to deliver in any of these formats and could change at any time. So in other words, they would deliver in one format one time and another the next time, depending on what their whim is. Could you imagine if this was done in production? It would be chaos, and it's the equivalent of dropping a bomb on the other side's preparation and workflow. So what you need to do here is get specific. And you need to get specific about the technical details of your exhibit exchange. Perform a sample exchange and document their agreement. Next, we're going to talk about hidden cost drivers at trial. So poor project management, the who, what, why, and when of the data decisions and history of your case. If you don't know what data you have or the history, for example, production info or how an exhibit was used in a prior trial, time spent in quality project management will save you when you're trying to find the detail, status, and what your data map is. Support for a trial site can collapse if there is not a good understanding of the data map, which goes to the heart of team organization. That Cornell study, once again, rears its head with organization being a top priority. Video clipping. Teams tend to over-designate video and not discuss or understand the process enough before giving instruction to clip video. Also, data acquisition. This is the process of obtaining data from both friendly and unfriendly sources. For example, in an MDL, the work is repeated over and over with firms duplicating effort. So you'll want to look for shared online tools to get the job done, with the added benefit that the efficiency gains you make will make legal ops people happy. There was an expression I once heard amongst a team that wasn't acquiring data efficiently and they didn't have a cloud-based repository. They said, if we had this all in the cloud, 2 could do the work of 14. So last, local data. You simply can't print from the cloud as you do from a file located on your local PC. Cloud performance does not yet equal local site performance. So you need to measure these things before you go to trial if you're off-site. So next is bad data practices, which cause teams to fail by virtue of months of bad planning. So for example, poor designations and issue coding in your transcript management tool of choice. Or your data tools, your document review tools. Not bringing a local copy of data when you're off-site at trial. And no backup or redundancy of your equipment and files. All of these things are very important. And if you don't do them, you can have lots of problems at your trial site and lots of additional tasks that you'll have to do to get your data ready, which tends to compound itself if you're waiting for a case to settle and you're not doing anything to analyze the data. So next are stories about bad trial tech behavior. I think attorneys and judges would be horrified if they knew some of the things that were going on here. I have to think firms are largely unaware of what's going on behind the scenes. And it's really putting them in a bad position before the trial starts, because we're documenting all these bad behaviors in case it reaches a level that needs to be reported to the judge. So there's lots of stories here. So for example, one of them is holding the trial site hostage so a vendor can use their own equipment and charge for it. Sure, there are exceptions here. But when equipment is provided by one of the legal teams, they likely don't have backups in place like a rental vendor would in case a piece of their equipment fails. It would be terrible if the equipment failed right before your opening, so you couldn't do your presentation as you had practiced and prepared for days and weeks. So this is why I highly recommend a third-party equipment rental vendor. I often now bring an associate with me, which stops some of the gamesmanship. But we also see a lot of games with video where unscrupulous teams synchronize an exhibit to play over a person's face so you avoid the reaction, or they put up an exhibit synchronized to the video that they shouldn't be putting up. And at that point, it's too late. And last, it's burden shifting. And we've talked a little bit about this previously, but that's where you're putting the other team in a position to have to do the work, the other team's work. For example, not naming or branding files correctly or zipping a bunch of files up into a single file. It may not sound like a big deal, but in volume, this can be very expensive and time-consuming and takes away from the team's own support and causes delay. If you find yourself in a burden-shifting situation, you should first discuss with the lead attorney if it's something they want to pursue. Second, you need to document it and demonstrate the burden being caused and give the offending team a chance to fix it. If they don't, go to the judge. The next section is preparing. We're going to discuss the importance of the site visit, workflow, and go over a few technical choices. Analyzing and practicing your workflow, including with vendors and consultants, is one of the most important trial tasks that you can do. This typically is for exhibit processing, binder creation, and version control. You want to deliver the same work product over and over and over like a widget factory. Be sure to discuss the time frame and expectations for after hours and weekends. Perhaps the most important role at trial is the gatekeeper. And this is a person who should handle all exhibit handling and processing to ensure that exhibits are processed consistently and handed over to the trial tech and team, as exhibits are often lost or the wrong version is used when handled ad hoc. This role can be served by whomever has overall responsibility for managing the exhibits, which could be an attorney, a tech, or a paralegal, who will also manage the version control of exhibits. You'll want to make sure everybody is printing the right version of the exhibit, using them in their casework, and it's definitely putting it up on the screen in the courtroom. Of course, this is all maintained in a project plan that tracks the exhibits, redactions, and replacements. Having a version control scheme for exhibits is important because when teams lose control of exhibits, the entire case is put in jeopardy of displaying the wrong exhibit, something unredacted, or not having the file at all. It just never makes it over to the technician. Now, a very important component of trial planning is the site visit. You would be surprised how many don't. My evaluation and testing takes 30 minutes to an hour, sometimes more. And I can't imagine teams coming in day of a court and simply plugging in. It just doesn't work that way. First, you'll make the clerk and possibly the judge angry. And then you'll likely be in a hurry and may not be able to configure your equipment correctly, which we'll see the effect of that in a couple of slides. I don't feel an obligation to assist those who don't plan ahead or are uncooperative. Although in the spirit of cooperation, I do help. I definitely make the other team ask for permission from my legal team, which can be an embarrassing slap to their credibility. Teamwork. So this isn't really a technical thing, but I thought it was worth mentioning. Preparing your team for trial is often overlooked by lawyers. They forget that members of their staff may have never been to trial or told how to act. I've seen trial team members strike up a conversation with jurors or talk loudly in the halls and treat people disrespectfully. This isn't limited to staff. I've testified about bad attorney behavior on 2 occasions. So it's important to engage with your team. And here are some suggestions. So one of the first things you want to do is make sure you have the right support for your team. Do you have every single role of your team covered, and which of those roles may need a backup? So for example, technicians, we often employ 2 trial technologists so that you have an overnight support person that can help and let the person presenting in court get some rest. We're all good for a day or 2 of all-nighters, but I don't think that's sustainable over time. One thing that's important is training your team about how to act at trial. Don't bunch up into a giant group. Keep your voices down. Be polite. Open doors. Don't talk to jurors. A lot of people just that work at law firms don't know that because their only experience at court may have been to pay a ticket or if they've even done that. One thing that's important is integrating your legal team so that they have ownership. And there's a couple of ways you can do that. One thing is involving them in your opening and closing practice walkthroughs and getting their opinion. It's actually very valuable to have the opinion of laymen versus attorneys when you're doing these walkthroughs. And there's been some amazing input. I think some of the best input I've ever heard has been from laymen telling attorneys, hey, that won't fly very well. There's other team-oriented things that you can do. Like I know a paralegal that leads his team in push-ups and exercises, or a dance-off, or puts a bunch of family for a particularly long trial. Maybe you want to put pictures of people's families as a discussion point, their dogs, their cats, whoever. But just a point where the team can get together and become a team. So how is information shared at trial? It's very important that lead counsel in the case finds a way to push information down to their legal team members. And you can use a whiteboard or a designated person. You also want to make sure that they're designated, that there's a way to incentivize and support your team at trial. So it's not for everyone. And you want to give people a way out without penalty, and you want to move uncooperative people out quickly because they quickly can poison a team. Now, document authenticity is an idea about keeping the document in its original state as possible. You're trying to show decision makers that you are an amazingly honest person. You want to be the truth teller. So this is part of how you do it. It's a warts and all approach where files are not visually improved via darkening, straightening, and sharpening. And if they are, it's explained to the jury. Many of these decisions are often made without attorney input. Could you imagine being asked in court if the exhibits have been tampered with? You should consider whether your improvements might be considered manipulation. One example I had at a trial was the angry signature. This is where an exhibit was made to look like an angry signature by darkening the file electronically. It was just their normal signature, but the process changed how the exhibit could be characterized. So be careful and be on guard. And some like a difficult document as it gives them more time to explain. Next, we're talking about a rule of thumb for time. I've included some estimates for many common tasks, but by far the most common time-consuming task is video editing, especially from transcripts. The request is often made without any consideration of how long it might take and is a good area for text to push back on and discuss. There could be long areas of pauses in the middle of text, and objections need to be removed, which means someone needs to read and review after the clip is created. It should be thought of as a strategic use of your support's time. So having a discussion is important before just relaying wholesale instructions to clip everything. So for example, 110-minute clips could be nearly 66 hours of video clipping, nearly a full week. This slide is about which tech format is best for use in exhibit exchange. By far, the most popular now is PDF, but there are a number of times where a different format is more appropriate. In a case where you have multiple exhibits with thousands of pages, a PDF is probably not the best choice, but will require a tech evaluation to determine what the best format is. These decisions shouldn't be taken lightly, as conversion of electronic files, branding, and OCR can cost a lot of money. It's a good idea to get your techs on the phone and talking early. A run report is the report created by your trial presentation software that contains the amount of time it takes for your designated clips to play. Teams are often surprised to learn that clips they thought might be a few seconds could actually be a few minutes. So finding those clips that aren't worth the extra time is important to managing your trial clock. Of course, this is who the deponent is. You'll want to know how long each clip is and the total amount of time for your clips. And it's important to closely review this, that it matches your expectation of time. Firms often make very poor decisions on equipment selection. It's hard to get support for buying the high-end laptops that are often necessary for trial. And you can imagine how a conversation goes when you ask for a high-end gaming laptop due to its video capability. The typical response is, you must be crazy. You only use that a few times. But if you don't have the right equipment, you'll put your case at risk every time you go to trial. So make sure you have the right equipment or are using a consultant that does. Also keep in mind that you need to. I just wanted to point out that the book has a number of checklists and forms to help you plan and prepare. Next, we're talking about presenting. Now, It's very important when you're presenting that you come in and establish a routine. And you arrive before the rest of the legal team when court opens so that you have a time to prepare and set up your equipment. That extra 5 or 10 minutes is invaluable when you're trying to figure out if a cable got vacuumed up last night or is disconnected. You need to test equipment exhaustively at breaks and lunch and when you get there in the morning. And have a backup plan and, of course, practice. Your presentation strategy is important, and I typically recommend a strategy that keeps it moving and interesting by using a variety of tech and no technique, a variety of tech and no tech techniques like trial software and boards. I've included a chart here as to the strengths and weaknesses of PowerPoint versus trial presentation software. Generally, PowerPoint is better for opening and closings that are pre-programmed because it's a little prettier and you can add titles and headings, while trial software is better in witness examinations where you need flexibility. Legibility, practice, and communication are all important. On communication, lead your audience via stage direction, which we'll talk about in a second. Don't overcomplicate exhibit naming because it'll confuse people. And always provide an outline to your tech in advance. Now, one thing that's important is that your presentations are legible in the courtroom. Many are not. So you want to make sure decision makers can see your presentation. It's important to evaluate the courtroom environment for legibility, monitor shape, and color capability. You never know where the equipment might be placed and how far it is away from viewers, so it's important to test. Also, many courtrooms with existing equipment are pretty beat up or old, so you won't know what resolution it can display at. This is important because the computer you are using and creating the presentation on is likely high resolution, and the courtroom equipment is probably low resolution. The effect is that your presentation won't look right on the lower resolution system. There's lots of potential problems with color, typically yellow. You don't want to create your presentation on a big screen monitor and then shrink it to a square monitor. So test and understand your environment so you can tailor your presentation to it. And your presentation may grow, shrink, and stretch if the presentation is not matched to the shape of the monitors. For example, in PowerPoint, you can choose between a square or rectangle. If they are mismatched, you'll get bars on the side of your presentation, shrinking the viewable area. I can't tell you how many trials I go to where you simply can't see the other side's presentation due to bad configuration and planning. And this is what documents look like when they're stretched or if there's bars on the side. You minimize the viewable area, making it not viewable from across the room, or it's stretched and it's just illegible. And a lot of that is because you have courtroom environments that have two different kinds of monitors, and it either stretches or puts bars on the monitors, and it just really messes with how your presentations look that you've spent so much time on. Next is stage direction. And stage direction is used in theater to tell the actors where to stand on stage. Stage direction in trial presentation is helping to direct your viewers where to look in the exhibit. Lawyers are often overly familiar with their docs and assume everyone else can keep up. They can't. Lead your audience to where you want them to see by describing exhibit number, document type, paragraph number, and the sentence. It's a good idea also to do a tutorial on what an exhibit number is and where it can be found. Now, elements of a successful outline are large font so that you can see it from the podium, screenshots so that you'll instantly know where the file information is, and color-coded exhibits. This is great because it can help you create a workflow that gets your team involved in making sure everything is QC'd and processed right and is ready for presentation. I recommend that you give an exhibit tutorial. A lot of people don't know what an exhibit number is, where it can be found, and so they don't confuse with old page baits or production numbers. Always use the exhibit number to refer to your exhibits. I mean, you can add additional description like it's a memo or the memo or something like that, but Exhibit 22 is the memo. The language of trial presentation, call out is a enlarged portion of the document over the document, highlight, and zooming Beware the yellow wall. It becomes, we have an expression, if everything is highlighted, nothing is. So I like to use a lot of color, and it helps distinguish your presentation, and a good way to direct everyone's eye. So with that, I'm done with my main presentation, and I'm happy to answer any questions that you may have.
Yes, and thank you, Shannon, for all that amazing information and detail there. And a quick reminder to our viewers that if you'd like to submit a question through to Shannon, you would use the purple icon at the bottom of your screen to send a question through. We do have some that have come through already. And Anna has sent in a question that says, do you recommend using tablets at trial?
Now, this is really interesting. I don't really feel that tablets are ready for prime time. You may have a use case where you have a very small set of data, and the tablet might be a better way to present in that situation. But tablets sometimes need to be plugged in using an unwieldy adapter, or you may have to bring in like a Wi-Fi system or some other system to present the information that's on there. So they can be even more technically difficult than plugging in a laptop to a monitor and a projector. Also, they're not as powerful as a trial laptop is, so you don't have the ability to do a lot of stuff on the fly or make a bunch of modifications. So it might be good for very small uses, but small and specific uses. But in general, I think you still want to use a powerful trial laptop.
Fantastic. And a question has come in from Shannon. And Shannon says, can you recommend any trial software or equipment?
Well, there's so many great options now. My book includes walkthroughs and how-tos of the basics for 3 of the top trial presentation software. Trial Director, Sanction, made by Lexis, and OnCue. There's also some really interesting newcomers coming. For example, I heard, I think it's called Mastro software. So I don't really make a recommendation as to which one is best. What I recommend, and what I go through in the book, is that you try them out. They all have trial periods. Find out what works for you, and talk to their tech people and see if they're available and helpful. So, and then on equipment, I find it's really expensive and to maintain a large trial equipment set. So that's why I really lobby people hard at trial to have a relationship with a third-party rental vendor or more than one, so that you don't have to buy and maintain a bunch of equipment. You may want just to have your trial laptop. You can even rent your trial laptop, I believe. So I don't really recommend a large inventory of equipment that quickly becomes outdated, banged up. A good third-party vendor is going to help you out and have backups and service and support and help you carry it.
Super. And a question in from Dana. And Dana says, how do you best allow for evidence rulings that may prevent use of a fact in a slide that may be ruled inadmissible?
Could you repeat that?
Yes.
Repeat, that was kind of a long one.
Yeah,
So
that was a long question. So how do you best allow for evidence rulings that may prevent use of a fact in a slide that may be ruled inadmissible? I'm actually going to push this to the slide area so everybody can see that too.
Okay. So I think we see this a lot, actually quite a bit. So for example, you may have an opening and it has red color in the slide or something along those lines, and it's looked at negatively by the judge and so you have to remove all the red colors. If you have an exhibit, you may have to redact information right there, and that's one reason why it's really important to have a good trial laptop, because that would be nearly impossible to do on a tablet. So having 2 computers so you can make those modifications on one computer while you're presenting on the other. It gets busy on they call it the hot seat for a reason, because it gets busy and you're under a lot of stress. It's not for everybody. But being able to work on one computer while while presenting on the other is a good way to set that up so you can make changes to your presentation. Also, there are ways of creating your presentation that is more efficient and technically better. That it's important. Why you might want to use, for example, a good graphic artist for the use of your PowerPoint. And that is because they may build the presentation using all sorts of elements rather than that can be taken out really easily versus, and I hope this is not too technical, doing a screenshot of something you've already composted somewhere and just inserting it in.
Thank you. Moving on to a question regarding PowerPoint. Michael says, when do you use PowerPoint and when trial software? So differentiating between those. Well,
I would encourage you to download the presentation because I have a chart in one of the slides there. And it shows typically we use PowerPoint for opening and closing and expert witness examinations, and trial software for more fluid examinations and uses of what we call on the fly, where you don't know what's going to be displayed or presented in trial ever. And so you may have to cut that video clip or redact an image and get that up on screen really quickly. So each has their own use and strength. You don't have to pre-plan every single exhibit you intend to show using trial software. You would have to do that using a PowerPoint slide. It's just not workable for witness examinations and that kind of thing. But take a look at the chart I prepared, and it's in the book as well.
Super. And question in here from Reese. Reese says, in the day of mobile devices, very topical question, what is the most effective way to extract text messages from phone while maintaining the authenticity of the time and the date stamps? What's your thought on that?
Well, that is actually a forensics question, computer forensics question, not a trial presentation question. But there's software out there that you can use to extract that information in a forensically sound way. I have a certificate in forensics from Cal State Fullerton. It's a really interesting field, and people do all sorts of things to their data so that you can't find it, of course, but that is more of a forensics question than a trial presentation question, and I love geeking out on stuff like that as well.
Great. And question in from Janelle, and Janelle says, do big law firms have an advantage using technology?
Well, this is really interesting, a really interesting question, because there's a lot of accusations that big law firms may have an advantage over smaller law firms, the kind of David and Goliath accusations that you hear all the time. I find that smaller law firms actually have the ability to be more nimble, meaning they can get the equipment that they need for trial. They have a one-on-one relationship often with the other attorneys, so they can get the training they need. And it's a little bit harder in the bureaucracy of a big law firm. So I don't think that it's kind of like the old Wild Wild West, where there is the gun is the great equalizer. It's the same thing with trial software. It allows you to bring a lot of capability and persuasiveness to your legal team without having a giant support structure. And we talk about that a lot in the book as well.
So we have time to squeeze in one more question.
Sure.
You're up for it, Shannon?
Yes.
And the question is, what skills are necessary to become a trial tech?
What skills are necessary to become a trial tech? So it's actually a very unique role. You need to be able to have the trial presentation software knowledge. But you also need to be able to be creative and flexible because you're creating artistic things all the time. And some IT skills and people skills, because you're going to be in courtrooms basically building an office that people are going to use for a period of time at trial. And you need to be able to have those IT skills to troubleshoot, like a cable breaks or the computer is on the fritz or whatever it is. And so missing any one of those areas can be kind of problematic. The trial software itself is not all that difficult. It's all the skills that surround it that I wrote about in my book and called it the Trial Presentation Companion, because I found that people lacked those companion skills. So